Welcome everyone to the Law Council of Australia's online event, Closing the Justice Gap, Implementing the Australian Law Reform Commission's Pathways to Justice Roadmap. My name is Pauline Wright. I'm the President of the Law Council and the moderator of this event. And I'm speaking to you from Darkinjung country on the central coast of New South Wales. And I'm delighted to introduce Mr. Eddie Kubilo to provide the welcome to country. Mr. Kubilo is an Aboriginal man with strong family links to both the urban and rural areas throughout the Northern Territory. He's a descendant of the Larrakia, Wodjigin and Central Arrente people, and was admitted to practice law in the Supreme Court of the Northern Territory. In 2010, Mr. Kubilo was appointed to the Anti-Discrimination Commission as the Commissioner of Northern Territory. He then took on the role of Executive Officer with the National Aboriginal and Torres Strait Islander Legal Service. Mr. Kubilo has also been a former chair of both the North Australian Aboriginal Justice Agency and the Aboriginal Justice Advisory Committee. In 2015, he was named the National Indigenous Legal Professional of the Year, and in 2016 attended Geneva on a UN Indigenous Fellowship. In 2017, he then took up an opportunity to work on the Royal Commission into the protection and detention of children in the Northern Territory as the Director of Community Engagement. Mr. Kubilo is currently undertaking a PhD and is working part-time at the University of Melbourne's Law School as a Senior Fellow. He's a member of the Law Council's Indigenous Legal Issues Committee and Indigenous Incarceration Working Group, and champions the right of Indigenous Australians within the legal context. So welcome very much, Eddie Kubilo. We're pleased to have you here.
Thank you. I'm pleased to be here. In these COVID times, I would like to take this opportunity to acknowledge all the Indigenous nations of this country, in particular the elders, past, present, and also the emerging leaders. I want to acknowledge the resilience of our people. We have kept our languages, culture, and our laws alive under great duress. Despite colonialism and an imposed foreign legal system, we continue to survive. This legal system speaks of the rule of law and the equality before the law, but neither could be argued that afforded to our peoples. In its 2017 report, Pathways to Justice, the Australian Law Reform Commission identified the drivers of the overrepresentation of Aboriginal and Torres Strait Islander peoples in the justice system. The Commission explained that this is a reflection of the multiple and layered nature of entrenched disadvantage we face, including social, cultural, and economic forms. Some of these disadvantages caused by systemic racism in the legal system. It should be noted that the federal government has never publicly responded to the ALRC's report. And while we wait for the government to respond, things are getting worse. Since the Prime Minister Rudd's national apology to the stolen generation in 2008, rates of incarceration and child removal have almost doubled. The Family Matters Report 2018 projected that the population of Aboriginal and Torres Strait Islander children living in out-of-home care will more than triple by 2037. We should all know by now the grim reality of Indigenous incarceration. Aboriginal and Torres Strait Islanders make up almost 3% of the total Australian population, but represent 28% of the adult prison population. Indigenous incarceration has increased by 45% since 2008. This is a frightening picture of Indigenous people's continued entanglement with the justice industry. This should be a concern for all Australians. It should be a special concern for all of us here at this gathering today. A concentrated and sustained commitment is needed to properly respond to the ALRC's recommendations and do justice to what Indigenous peoples in this country have been saying for a long time. In acknowledging country, I acknowledge our collective obligation to First Nations peoples across Australia, where sovereignty was never ceded, to take up the struggle for justice. We are not statistics. We're entitled to more than this system, and the only way to get there is to have the challenging discussions, but we must then follow through with effecting change through lobbying, activism, and struggle is now what's needed. We as a profession, we cannot continue to be complicit in this status quo. So I just wish that everyone has a good forum today.
Thank you very much, Eddie. That's very much appreciated, that acknowledgement and your heartfelt remarks. It's an important forum and we're very grateful to you. And I Acknowledge the Ngunnawal people, who are the traditional custodians of the land on which the Law Council Secretariat is situated, and I'd like to pay my respects to their elders past and present, and I extend this respect to the traditional custodians of all the lands from which attendees dial in to be with us this evening, and to all Aboriginal and Torres Strait Islander elders who may be in attendance. The Law Council is honoured to present a panel discussion this evening with renowned advocates, academics and leaders in their fields. Dr. Hannah McGlade, Ms. Cheryl Axleby is not with us, but I'll come to that in a moment. Dr. Tracey McIntosh and Mr. Tony McAvoy, SC. Hannah McGlade is a Noongar woman and lawyer and academic from Western Australia. She's currently Associate Professor at the Curtin University Law School, a member of the Medical Board of Australia and an expert member of the UN Permanent Forum for Indigenous Issues. On the program, we did have Cheryl Axleby, who's the co-chair of Change the Record, joining us tonight. Unfortunately, due to unforeseen circumstances, she can't be with us. But we are honoured and delighted instead to welcome Carly Warner in her place. Carly is a Tasmanian Aboriginal woman and lawyer who grew up in Yorta Yorta and Doodaroa country. She's currently the Chief Executive Officer of the Aboriginal Legal Service of New South Wales and the ACT, having previously been Executive Officer of the national peak body, the National Australian and Torres Strait Islander Legal Services, or NATSLs. Before working in legal policy, Ms. Warner was practising as a lawyer at the Victorian Aboriginal Legal Service, with experience working across criminal, civil, child protection and family law. And Tracey McIntosh is a sociologist, Professor of Indigenous Studies and co-head of the School of Maori Studies and Pacific Studies at the University of Auckland. She's the Chief Science Advisor for the Ministry of Social Development, Commissioner for the Criminal Cases Review Commission, and has undertaken extensive research on incarceration issues. And finally, but not least, we have Tony McAvoy, SC. Tony is a Wiradjuri man from Central Queensland and a barrister and senior counsel with expertise in many areas, including native title, human rights and discrimination law, coronial inquests and criminal law. Mr. McAvoy SC made history as the first Indigenous senior counsel in Australia when he was appointed in 2015. We're here this evening to examine the alarmingly high rates of incarceration of Aboriginal and Torres Strait Islander peoples in Australia's criminal justice system. It's often remarked that Indigenous Australians are the most incarcerated people on earth. The Law Council considers this to be a national tragedy deserving urgent attention. There have been countless independent reports published in the past decades. They're sitting on shelves. The Australian Law Reform Commission's Pathways to Justice report is a highly pertinent and comprehensive national report, and one of the latest in a long line of reports calling for change. However, more than 2 years since the final report was tabled in March 2018, there has only been sporadic engagement with many of its specific recommendations by governments. The ALRC was asked to consider the legal and policy frameworks that contribute to the incarceration rate of Aboriginal and Torres Strait Islander peoples and inform decisions that hold them in custody. It found Aboriginal and Torres Strait Islander people fare worse at every stage of the criminal justice process compared to non-Indigenous people. In 2016, they were 7 times more likely than non-Indigenous people to be charged with a criminal offence and to appear before the courts, 11 times more likely to be held in prison on remand awaiting trial or sentence, and 12.5 times more likely to receive a sentence of imprisonment for like offences. A large proportion of this group who are held on remand do not end up receiving a custodial sentence at all, particularly Aboriginal women, due to their offending being low level. The same applies to young people. Up to 45% of Aboriginal and Torres Strait Islander offenders sentenced in 2015 to 16 received a sentence of imprisonment of less than 6 months and are less likely to receive a community-based sentence than non-Indigenous offenders. Aboriginal and Torres Strait Islander people may also be disproportionately affected by mandatory sentencing, which of course increases incarceration cost and does not deter crime. For Aboriginal and Torres Strait Islander people, there are specific access to justice issues, including a lack of interpreter services. Fine enforcement regimes disproportionately affect Indigenous Australians. There are strong concerns by First Nations groups, backed up by evidence that suggests police apply the law unequally. For example, Aboriginal and Torres Strait Islander young people are less likely to be cautioned and more likely to be charged than non-Indigenous young people for the same sorts of behaviours. There were 35 recommendations handed down, including Commonwealth, state and territory governments should support justice reinvestment trials. State and territory bail laws should be amended to include standalone provisions that require bail authorities to consider any issues that arise due to a person's Aboriginality. However, this would not supersede considerations of community safety. Another recommendation was that sentencing legislation should provide that when sentencing Aboriginal and Torres Strait Islander offenders, courts take into account unique systemic and background factors affecting Aboriginal and Torres Strait Islander peoples. Commonwealth, state and territory governments should repeal legislation imposing mandatory imprisonment. Where needed, state and territory governments should establish specialist Aboriginal and Torres Strait Islander sentencing courts. Prison programs should be developed which address offending behaviours and prepare people for release. Statutory parole regimes should be reformed for prisoners with short sentences. Fine default should not result in the imprisonment of the defaulter. Never. Commonwealth, state and territory governments should, firstly, review police procedures and practices so that the law is enforced without discrimination. Secondly, review police complaints handling mechanisms to ensure greater accountability. Thirdly, introduce a statutory requirement for police to contact an Aboriginal and Torres Strait Islander legal service after an Indigenous person is detained in custody. And fourthly, enhance cultural change within police. The Commonwealth Government, in consultation with state and territory governments, should develop national criminal justice targets. So, the biggest shift that's occurred following the report's release relates to that last recommendation. Earlier this year, a new national agreement on closing the gap was announced for the first time, and it includes justice targets to reduce the incarceration of Indigenous adults by 15% and Indigenous children by 30% by 2031. Some people have criticised these targets as being not ambitious enough, but it does provide a new opportunity for all governments to closely consider the detailed ALRC framework for change. There's no need to reinvent the wheel. The work has been done and it just needs to be implemented. In terms of tonight's process, I'll put a number of questions to the panellists, and if there's time at the end, and hopefully there will be, we'll also hope to include some questions from those of you out there watching. We invite attendees to submit questions throughout tonight's discussion using the Q&A function. And you can access that by clicking on the picture of the speech bubble, which should appear when you run your mouse over the bottom of your screen. You can then type your question to our moderators and they will in turn try to divide those up into themes and ask some questions of the panel. So I would now like to address some questions to each of our panellists. I'll ask each of you to reflect on the Australian Law Reform Commission's Pathways to Justice report and let us have your thoughts on why was it so significant and where has the greatest progress been made in implementing the findings in Australia, either in terms of particular jurisdictions or specific recommendations, and where has progress stalled? I'll start perhaps with Tony McAvoy, then go to Hannah McGlade and then Carly Warner. Tracey will save you for a specific question in relation to New Zealand. Thanks, Tony.
Thank you, Pauline. I too acknowledge the First Nations all over the country. I acknowledge the country that I'm on, the Marigal country. I acknowledge my own people. And I should acknowledge also the panelists. From my perspective, the Pathways to Justice report was particularly significant for two reasons. Firstly, because it has formed the matching piece to the report in the Royal Commission into the Protection and Detention of Children in the Northern Territory. If you recall, that Royal Commission commenced in July 2016. The inquiry, the referral to the Australian Law Reform Commission occurred shortly after. And when you look at the two documents, you will see that it provides a roadmap with respect to both children and adults. And so the Pathways to Justice report really focused on adults. It didn't have a particular mandate to deal with children, and that's the reason for the last of the recommendations, which recommends a national inquiry into children and out-of-home care. It had the effect of providing really, when read together with the Dondale Royal Commission report, which was very comprehensive and has much wider ramifications than just the Northern Territory. It provides a whole of system analysis and guidebook. The second reason that I think that the report was significant is that the report is of such a high quality, and that is an indication, I think, of the quality of the submissions that were made to that report. Almost all justice agencies and community organisations made submissions. And the advisory committee to the ALRC was full of extraordinary people who have great experience in this area. And I was lucky enough to be on that committee and to be able to assist. I know, Pauline, you were on that committee. Hannah, you were on the committee. I'm not sure whether Carly was. No. But that committee provided, I think, the Australian Law Reform Commission with the guidance and insight to ensure that the issues were well fleshed out and understood, and the recommendations were very well targeted. And so for me, that's the highlights, I suppose, and the most significant aspects of that report.
Thanks very much, Tony. Hannah McGlade, what are your thoughts about it?
Yes, it was really very significant human rights work that was undertaken and achieved by the Law Reform Commission. And I think, following from many years ago with the Royal Commission into Aboriginal deaths in custody, we've had, 25 years since of ever increasing incarceration of Aboriginal people, particularly women and children at quite at shocking levels. So, this is a national human rights issue facing all of Australia, particularly Aboriginal people who are being harmed in serious ways, including the intergenerational harm that's resulting from the incarceration experience and the trauma associated with it. The Royal Commission was criticised for failing to address the issue of women's, the violence against Indigenous women, and there weren't that many deaths of women looked at, but this report was very careful about ensuring that the issues confronting Aboriginal women were faced. So look, we're dealing with a problem of such magnitude. I think we're very consistent with what's happening in the US to African American people, and that it can aptly be described as mass incarceration of people. And for Aboriginal people, we know that incarceration was really a part of, fundamental to the colonisation experience. The first public building in West Australia, I like to tell people, was the Roundhouse, and it was used to incarcerate enslaved Aboriginal men who were resisting the violence of colonisation and the laws that were akin to slavery at that time. And this history has really not abated. It's very cruel what we're seeing in what can also be described as a prison industry. So, I think from that perspective of human rights, Aboriginal fundamental human rights, and our dire need to address, what truly has been a very cruel and genocidal past, this report really has so much to contribute.
Thanks very much. Tracey, are you, I'm sorry, I've lost you for a moment. Carly, are you there?
I am.
Thank you. I'd love to hear from you in terms of what you think of the report, and perhaps even where it might have stalled.
Yeah, thank you. I think this was really quite significant, and as Tony sort of alluded to, this was commissioned by government to comprehensively examine the unacceptably high incarceration rates of our people. And then, as Hannah's mentioned, this has been done before, and it's been almost 30 years since the Royal Commission into Aboriginal Deaths in Custody. But I think, as you said, Pauline, there's been many other reports as well since that time. And I know even in New South Wales at the moment, there is a New South Wales inquiry into incarceration rates, and also into deaths in custody, and into the accountability mechanisms. It's really, really unfortunate that we still haven't had any responses in relation to this. And I think any responses both at the national but also at the jurisdictional level, I acknowledge that there has been some developments. We do have justice targets now. We do have custody notification services. At the time, ALS New South Wales ACT was the only Aboriginal legal service in the country that had a Commonwealth funded custody notification service. We do have custody notification services now, which have been rolled out or are in the process of being rolled out at ALSs around the country. I would say, of course, that trying to ensure that there's adequate funding for those has also been not without its challenges. But there are just, despite those kind of things, that there has been progress. There's many of the other recommendations, notwithstanding not even having that national response, have not been implemented. And, I know it's sort of the specific sentencing courts is one. And, I note in New South Wales, since 2014, a working group developed a proposal for the Attorney General for the Wallumer Court in New South Wales, which of course is kind of modelled on a mix of the County Koori Court in Victoria and the Drug Court in Victoria. We're now in 2020, and this proposal that was developed by a number of experts in New South Wales has still had nothing done with it. So, it's not just the national response we're still waiting on, it's also the jurisdictional responses that they could have just got on and started implementing these recommendations at the local level. But unfortunately, we're not seeing that. And I think that the only conclusion I can come to is that we are less than 3% of the population, and that our lives and making sure that we're thriving sort of within our families, within our communities, on country, is not a priority for the politicians who are meant to represent all of us, who are meant to get on and do their job for the minority. And it's really disappointing, and really great to see so many people dial into this webinar, because ultimately we do make up 3% of the population and we need all of you.
Thanks very much, Carly. I think you're absolutely right. It's a shameful indictment that this is happening, but it's the majority of Australia that has to get behind these initiatives for it to have traction with our politicians. So thank you for that. Tracey, I've got a question for you. How do New Zealand's over-incarceration rates of Maori peoples currently compared to the Australian situation? Do you think the New Zealand's ahead of Australia on this issue? And if so, in what areas?
Kia ora hui mai tātou, kia ora koutou katoa, Māori ora ki a koutou, ngā mihi ki a koutou. E te mana whenua, tēnā koutou. I'd just like to really acknowledge those of you who hold customary title, who hold the authority and the mana, the power and the prestige of the land. And just thank you also for the welcome today. I mean, it's one of these absolutely terrible things that, you know, you nearly have a hierarchy of suffering. When you look at incarceration of Indigenous peoples across the settler states, we just see this gross disproportionality. And this gross disproportionality, as Hannah says, has huge intergenerational reach. So in New Zealand, we make up nearly 17% of the population. And we make up 50% of the prison population. If we disaggregate that, if we look at, for example, wahine Māori women, we make up 63% of the women's prison population. So there's a whole lot of things in doing that. We actually have a higher incarceration rate as our rate than Australia, you know, which people do remark on in New Zealand, given we didn't start our settler lives as a penal colony. And yet we have a higher incarceration rate. Once you disaggregate that rate, so at the moment, you know, it has been as high as 200 per 100,000. This is a non-disaggregated rate, and around 717 per 100,000 for Māori. Now, obviously, when you look at your rates, and particularly when you disaggregate those rates, it's a devastating story in Australia. So that devastation, I think, is really felt. It's felt very deeply. It's embedded in our communities. We recognise that the reach, as I've said, of the prison is so long, and certainly outside of the wire. And so when we have mass incarceration, we have what we would call hyper incarceration, then the reach of the prison goes well deep into the communities. And for me, you know, that is really the way I think about mass incarceration, is when the impact of the prison impacts the communities of whence those people came, more than it even impacts those that sit within it. So it's a terrible thing, I think. It's sort of the violence we do when we start thinking about statistics. We have a devastating litany of statistics. And I think that there are some things that are very common between us, and there are things that are quite different. And I think it would be lovely to think about us showing, I guess, in a global leadership in both of our countries and turning this dismal story and this narrative around.
Thanks. Thanks very much, Tracey. It can be disheartening to think that this is a common experience for Indigenous peoples across the globe, I think. But it's something that I think we can do something about in Australia and New Zealand. And the Closing the Gap refresh justice targets, while, as I said, are insufficiently ambitious, as I think has been acknowledged by a lot of people, do provide a clear impetus to all governments to reconsider the Australian Law Reform Commission's Pathways to Justice report as a framework for change. So I might start again with Dr. Hannah McGlade. Which of its recommendations, in your view, offer the greatest potential wins in achieving these targets? And why do you think that? I'll put that question also to Tony McAvoy and to Carly after Hannah.
So there was the overarching recommendation about setting up a national justice reinvestment body to drive reforms. I think that is obviously, you know, very important, and also to re-establish the Aboriginal Justice Advisory Committees, or the AJACs, which were a recommendation of the Royal Commission into Aboriginal Deaths in Custody years ago. West Australia disbanded the AJAC and was the first state to do that, and we have the highest incarceration rates of men, women and children at this time. So certainly, you know, changing the frame, the mental frame about, you know, incarceration, the punitive approach and the law and order agenda seems quite strong this side of the country. Unfortunately, it seems like a vote catcher, but unfortunately, you know, for Aboriginal women, it's a situation of over policing and as you know, offender and under policing as victim. So certainly the AJAC, you know, reflects that fundamental human rights principle of self-determination. We simply cannot turn this situation around without that, that partnership and commitment to working together, which is what is supposed to be there. The COAG, closing the gap and the federal policy is all about, you know, working with in partnership with Aboriginal people. But unfortunately, in my side of the country, we're really not seeing that yet. So that is really significant. And secondly, I'll just say quickly that the recommendation about a Commonwealth inquiry into the connection between out-of-home care and subsequent Aboriginal youth detention, this inquiry couldn't focus on the situation of youth, but we know that that is the pathway to the criminal justice system and subsequent incarceration and harm. So there's this ongoing cycle, and if we can't, you know, get it right around the child protection, then, you know, we're really quite doomed. So that there are two really significant areas, I feel.
Thanks very much, Hannah. Thank you. Tony McAvoy, to you next. What are your thoughts in terms of the recommendations that might offer the greatest potential wins?
Thank you, Pauline. I have thought about this and broken it down into two categories, the short term and the longer term. In the short term, we can look at the results from the government COVID measures that were taken in New South Wales, which resulted in an 11% reduction in the prison population. And that was largely achieved through bail decisions and police decisions in terms of giving police bail. As regards the recommendations of the Australian Law Reform Commission, I think that in the short term, if we had a review of the bail laws, ensured that bail accommodation was made available, this would have a big effect. And we know that with children in particular, lack of bail accommodation is a huge factor, and it's a really sad indictment on our country that in the Northern Territory, for example, 75% of the young people in detention are there for because they've been bail refused, and the large percentage of those is because there's no suitable bail accommodation for them. And so essentially they're being imprisoned because they are poor. And as a country as affluent as Australia, it is mind-boggling that can occur. The other recommendations that I thought might assist in achieving some short-term gains is the establishment of community-based alternatives to custody. This can be done fairly easily and quickly, and we've seen one established in Alice Springs for women that's been reported in the media in the last few weeks. The enhancement of First Nations specialist sentencing courts. They are known to do very well, and just as they in New Zealand they have the Rangatahi court, we have circle sentencing courts, Koori courts, youth Koori courts, Koori County courts, and each of those courts add greatly to both reducing the number of people in jail and reducing recidivism. And finally, I think there's also a lot to be made of the use of Indigenous experience reports or Gladue style reports, explaining to judicial officers the unique situations of the individuals that come before them in a more in-depth manner, and ensuring that the court has a has a good understanding of the systemic and community problems facing the offender. There's one matter I need to raise that wasn't a part of the Australian Law Reform Commission report because of its limitations, and that is raising the minimum age of criminal responsibility to 14. That in itself would make a significant difference both in the short term, but also in the longer term, because we know that we would see less people filtering from youth justice into the adult criminal setting. In the long term, and this is really where the investment needs to be made, because what's needed is deep systemic change. It's not something that can be fixed with a tweaking legislation here or there. We are in the midst of an ongoing process that permits and almost needs our people to be incarcerated, and the way in which we approach that systemic change at the very least ought to include the Aboriginal Justice Advisory Committees that Hannah's talked about, so that our representatives and our experts can talk directly with the government about these issues in a holistic manner. And secondly, it is very difficult for me to understand how we have not had a full rollout of the justice reinvestment programs in Australia, when the pilot program at Burke, the Maranguka, has proved to be well worth the investment made by government, with fantastic figures. In one such figure was that there was a 39% reduction in domestic violence complaints as a result of the work of that program. That alone should justify expansion of that program, but it has succeeded on so many other levels. So that, it seems to me, is the future, where Aboriginal community organisations, Aboriginal and Torres Strait Islander community organisations on the ground are in control of the delivery of justice, rather than it being something that's imposed upon our communities. Thank you.
Thanks very much, Tony. I don't know if you have any thoughts as to whether a voice to Parliament would have that same sort of impact in terms of Indigenous people being listened to in a systemic way.
Of course, Pauline, if there is a requirement for bills which affect our people in the federal parliament to be the subject of advice and comment from our representatives, at least our interests are heard, which is not necessarily the case at the moment. We are heard, but our voices are mediated through the representatives in the parliament, whether they be independents or members of political parties. The difficulty, though, is that much of the reform that's needed to be undertaken is needed at the state government level, and whilst we could benefit from the comment at a federal level, there doesn't seem to me to be any reason why each of the state and territory governments ought not also set up their own advisory committees to advise on bills in the same way.
Okay, thank you very much. Thank you. Okay, Carly, do you have any thoughts on this issue? What do you think might work?
Thanks, Pauline. Lots of thoughts, but first, and I do acknowledge that it respected the country everywhere that we're meeting on, and so did you. But a slip of my tongue in protocol that I didn't acknowledge that I'm off country at the moment, and so I acknowledge I'm on Gadigal and Wongal land today, and pay my respects to the traditional owners. Just listening to that conversation then, and you know, Tony's absolutely right, that there have been so many families and communities, including community controlled organisations like Change the Record, NATSLs, the ALS's, families who have lost loved ones to deaths in custody, you know, calling for the government to invest in community controlled solutions. And that's what the Pathways to Justice report recommended. And so for me, there's no one single recommendation that is going to end the mass incarceration, but I feel like government is using this, oh, it's very complex kind of argument as a bit of paralysis to not act. And what we know is that those recommendations in the ALRC report, and indeed, you know, that many organisations and Aboriginal people have been calling for a long time, could be implemented, you know, tomorrow, 10 years ago, next week. And so I think the one that really underpins all of them is making sure that it is that there is a commitment to Aboriginal and community-led solutions. But we keep seeing that government is ignoring this fundamental principle, both at the national and also at the jurisdictional level. You know, we've seen the Commonwealth Government's decision to expand the cashless welfare card, and this just flies in the face of these key principles of self-determination and co-design and community leading, community developing the responses that are going to see them thrive at the local level. I think in terms of ones that, you know, are also particularly important for me, and I think Tony sort of touched on some of the elements that were missing for this, but for me, I think there was also that missing piece around child removal and the destruction that this has to families and communities. We knew from the Royal Commission into Aboriginal Deaths in Custody that of the 99 Aboriginal people whose deaths were examined by Ricketic, you know, almost half had experienced childhood separation from their families, you know, removed through intervention by the state or some other institution. And so I think that's something that we need to make sure is a priority. But for me, just get on and implement these recommendations.
And of course, that kind of wraparound community support that has been seen in Burke that Tony was talking about has had really terrific outcomes in that sense as well, in terms of children staying with family, children staying in school, so that people don't start on that cycle in the first place. So yeah, thanks very much.
Absolutely, Pauline. I might just say on that though, and we talk about rolling it out across the rest of the country, it's also probably pretty important to highlight that you know, Marinika and JR New South Wales, who are part of the ALS, are not actually getting backed government funding to the degree that perhaps most people think that they are. And so there are clear examples there of them working. And so we need to get in and make sure that those are resourced publicly, and also, of course, to roll out, as others have said.
Absolutely right. Thank you very much. Now, Tracey, do you have any comments on the recommendations in this report, or indeed other things that have really worked in New Zealand?
I mean, I think the justice reinvestment one is obviously a really important element when we have to really think about what does justice reinvestment mean. We don't want justice reinvestment to mean that we recreate the prison in the community. We don't want it meaning that we recreate all of the types. So, you know, we just shift the carceral into the community. And so it really, for it really to work, I think you have to do what Tony says and what all of you have said. You need complete structural shift. You know, what are the conditions necessary for a just society is the thing that we have to look at first before we start to think about what are the things that we need for a just justice system. One of the things, and we've also been very busy doing our reports, and they're very cyclical. In fact, 1988, like yourselves, was a really incredible year for us in terms of the reports. We had the really important report of Moana Jackson in regards to looking at Māori in the criminal justice system. We also had a really significant report led by John Rangiho in that same year, which was looking at our welfare system. And then 30 years later, we were doing those reports, what would have happened if we'd taken the recommendations in 1988 and actually implemented them? And it just, to think that we will allow we allowed another generation to sit within that harm and to reproduce that harm is just astonishing to me, and it really shows the incredible tolerance for Indigenous suffering. We had Julia Whaiputi on our, I was on the Te Wepu Hapai Te Ora, the Safe and Effective Justice Advisory Group. It was an independent group, but that was selected by our Minister of Justice, Andrew Little. And we had an incredible woman. Some of you will have seen her. She's very visible in many forums. Julia Whaiputi, who was on that advisory group with us. And, you know, Julia was born in 1988. She said she doesn't want to wait for her mokopuna, her grandchild, you know, in 30 years' time to be, you know, starting to think about what sort of report we should do to make a difference within the system. So one of the platforms that came out of our report, Turuki, was the need for transformative justice. And a focus, I guess, on transformative justice was the real need to move beyond a politics of reconciliation, a politics even of restorative justice, but to really think about what transformative justice means, what it means for the Crown to be truly accountable for the harms that it's done, what it means for what we call mana oriti, an equal partnership going forward, what it means in terms of different governance structures, what it means to lead and to commit to it, what it means to implement and to monitor. And so, you know, I really applaud the work that's been done within this report and recognise, you know, just how far we all need to go. We want to create the conditions where we go well beyond survival and really about how do we flourish as a community? How do we co-determine our futures? And I think co-determination is a really useful way of thinking about that, because it speaks to not just Indigenous futures, but also the futures of a broader nation. How do we co-determine the future going forward?
Thanks very much, Tracey. I think that's right. We need to create those conditions to flourish, not just survive. I think it's important to remember that for all of us looking at these issues. So, Hannah McGlade, I'll put this question to you. We know that Aboriginal women are the fastest growing prisoner population in Australia, for instance, looking at Victoria, and that they also experience very high rates of violence. Can you perhaps reflect for us on the reasons behind this and whether we need specific supports directed towards Aboriginal and Torres Strait Islander women?
Mm-hmm. Yes, that's right. It's been recognised for over a decade now that Aboriginal women, the prison population is increasing rapidly, and I think Aboriginal women in my state are around 50% of all prisoners, although we're about 3% of the population here. And that correlates with actually the level of Aboriginal children being removed as well. It's now up to about 56% of all the kids being removed here are Aboriginal children. And these are, you know, reasons that are dating back to colonisation and continuing, and certainly the violence of colonisation. The frontier violence was very profound, and Aboriginal women were not protected by the law. And I cover that in my book, Our Greatest Challenge, Aboriginal Children and Human Rights. And, you know, this is still a history that's been relatively recent and ongoing. The Stolen Generations really was around for, you know, up to the 60s or the 70s. I myself was at the Sister Kate's home as a girl. And there was enormous abuse of Aboriginal people through this history. And to this day, we're seeing highly abusive treatment of Aboriginal women in the justice system as well. So not just in the community where we know there's very high levels of interpersonal violence, with Aboriginal women being at very high risk of being murdered, actually, not just hospitalised with injuries, but shockingly high rates. And we see that structural violence, you know, replicated in the prisons and the, you know, the police. We have a police officer now charged with shooting Joyce Clark in Geraldton, charged with murder. And we've seen cases of Aboriginal women in prison have been treated in the most inhumane way, as if they aren't really, you know, human beings with human rights, women, being forced to give birth alone in a prison cell, being transported naked and bleeding to a psychiatric ward. And I wrote about these cases and the treatment of Aboriginal prisoners with disability in the Routledge Handbook of Disability Activism, if people are interested in that. So, you know, this is, you know, something that is very severe today, and we're simply not addressing it. It is contributing to men being incarcerated and women being incarcerated as well. And that often the incarceration charges are about acts intended to cause injury. You'll see from the report, this is, you know, being reflected. Aboriginal women as victims do fight back and are often left with no recourse of any safety from, you know, police or anybody else. So this is the only thing they can do. And we know that drug and substance abuse is a coping mechanism from violence and trauma. So there's this, you know, systemic structural drivers of the violence that are not abating, because basically government is really failing in its duty of care in terms of addressing this level of violence and the nature of the violence that Indigenous women are facing. And I've appeared before several UN treaty bodies, including the Committee on the Elimination of Discrimination Against Women, to advocate around these issues, including the abusive practice of strip searching in prison, of solitary confinement to women and men. But one of the key recommendations that's come out of several of the UN bodies is for a specific national action plan to address violence against Indigenous women. So that is really paramount. We have to keep saying it. We know in my state, the Gordon inquiry was actually 18 years ago, and key recommendations from that inquiry were neglected. And one of them was for a one-stop shop in the community to be supporting victims and helping communities, you know, to address this issue. And really sadly, we've had a younger suicide victim, an 11-year-old girl who was so fearful when police released on bail the person that she had identified as sexually abusing her violently since she was a little girl commit suicide. And we still don't even have an Aboriginal Children's Commission, which was also a recommendation of the Gordon inquiry. So we're seeing, you know, structural and systemic violence that we're actually describing as Indigenous femicide. And those issues are brought out in the Deathscapes research project, which is online. So I encourage people to look further into that. Thanks.
Thanks very much, Hannah. I mean, as you say, it's the over-policing of female Aboriginal people as offenders and the under-policing as victims, and we see the results of that very starkly. And it just drives home how important it is to look at justice reinvestment, investing in communities to address causes of violence instead of trying to criminalise people when they fight back, or criminalise them at all in the first place if the causes of violence can be addressed. Thank you very much. Carly Warner, you have worked as a lawyer, obviously, on the ground in legal policy roles in the public service, looking at this issue from an Australia-wide perspective at NATSLs, and now leading a critical on-the-ground Aboriginal legal service. From here, where are the roadblocks to achieving national improvements, and how do we overcome them? In your view, is it a matter of what will make a difference, such as law reforms and programs, or who will make a difference that matters most, or is it both?
Yeah, I think you've summed it up in the last part of that, Pauline. It's both. Like, we've seen a massive capital investment in expanding prisons and jails and more and more privatised prisons. Sentencing laws have been through radical changes, including the implementation of mandatory sentences, mandatory minimums, habitual offender laws like the 3 strikes, of course, many of the things that the ALRC Pathways to Justice report sought to address and make recommendations about. And in addition, you know, the criminal law has been expanded, dramatically increasing the number of societal behaviours for which there is now criminal liability, in turn widening the net of the justice system and the role of police. And, you know, where has that got us? In the past 10 years, the number of Aboriginal people charged by police in New South Wales has increased by more than 67%. For non-Aboriginal people, the increase has been just 8%. And this is despite actually a fall in crime rates across the state. So all of that in a nutshell for me, demonstrates that this is a mix of both what we do about it, but also who does something about it. And I said before, you know, that we're lacking political will for change. And I might eat my words now, having highlighted what I just have, because it appears that the political will is actually to continue to incarcerate Aboriginal people in this country. And, you know, as Dr. McGlade said just before, this is not just about even incarcerating Aboriginal people. We are seeing Aboriginal people assaulted, abused, suiciding, and even, you know, they're being killed essentially within this country. And politicians are continuing to let this happen. We've had solutions for years, for decades. As I mentioned, you know, some of the Aboriginal organisations before who've been calling out for things to repeal the discriminatory laws, to ensure that there is real police accountability. And yet we still see examples like from last week. You would have seen in media reports that a police officer was actually convicted of assault of an 18-year-old Aboriginal man in Goulburn and still has his job. What does this say about accountability for police misconduct in this country? What does it say about the institutions that are meant to serve and protect us, all of us? And what does it say about the political will to be willing to put a stop to what's been going on for so long? And the exciting thing is that, you know, we saw people from cities, from towns, from regional locations, from all across the world throughout this year come together to say enough is enough. You know, people of good conscience saying we want an end to this, and that support has been great. It's now is the time. We need to keep that momentum going.
Thanks very much. Do you think that there's a collective lack of imagination as to what the alternatives to incarceration might be within the broader Australian public? Because that ultimately is what drives politicians, isn't it? It's the public view, and there just seems to be no awareness of what the alternatives might look like. So what do we need to do as a profession to push that?
Look, I think on the one hand you could say yes, but then I also look at evidence like some of the recent surveys about raising the age across the country, and a majority of Australians said that they agree with raising the age. So the constituents of the politicians' own electorates are saying, we want to raise the age. And yet we're not seeing the age being raised in any of the jurisdictions yet. You know, we're really hopeful in the ACT with their commitments that we might see that. We might see that kind of eventuate in laws being changed there. But I think it's not a matter of people not supporting it. It's something, unfortunately, inherently deeper, systemic and racialised.
Yep. All right, thank you. On that note, Tony McAvoy, your work as a barrister gives you first-hand insight into the court's role in responding to First Nations legal issues as opposed to the politician's role. Are there emerging lessons to be learned in terms of best practice court approaches to over-incarceration, given that there's no political will to change it, it seems, at the moment?
Look, thanks, Pauline. I might just carry on a little bit on that question of political will. I think that Carly was being generous in asking a question rather than asserting it straight out, because one of the things that we've been facing in New South Wales with the attempts to convince the New South Wales government that an Aboriginal specialist sentencing court in the district court, the Wallumbilla Court, is an imperative in terms of trying to address the over-incarceration rate, and secondly, the funding for the enhancement of the Just Reinvest program out of Burke and the use of that program in other communities. The answer that we've been getting from the government is that the money doesn't exist, and it can't be funded because the money doesn't exist. While at the same time, we heard just a few months ago that the government had constructed a new 1,700 bed prison on the mid-north coast of New South Wales, deep in the heart of large Aboriginal populations, at the cost of $769 million. And that to me says in no uncertain terms that the political will is not there. And so what we are doing here, what we're all doing here, even at this in this webinar, is to try and assist the government in changing its will. And so, in answer to your question, there are a number of things I think that are emerging and have been learned about best practice. One of which I want to mention, and Hannah touched on it a bit, but it's one that hasn't really been embraced at the level that it has in North America, and particularly in Canada, but that is trauma-informed practice of law. And so the notion is that judicial officers, police, lawyers, all those involved in the justice system should understand what trauma-informed practice is, understand what trauma is and how it affects cognitive function, what effect it might have on criminal culpability. These are discussions we're yet to have in Australia. And in addition, an issue for Australia is an understanding also fetal alcohol spectrum disorder, FASD, which is a particular problem in Australia. There is some great work coming out of North America, and it's sorely needed in our courts and in our profession. We need to get on with doing that work, and in part, it's about ensuring that the witnesses and the victims and the offenders are assisted in a trauma-informed way. But it's also about the practitioners and the judicial officers protecting themselves and understanding their susceptibility to trauma as a result of vicarious trauma and the exposure to trauma on a regular basis. And I would be very surprised if those judicial officers who are dealing with violent criminal matters on a regular basis have not been subjected to some levels of vicarious trauma. And there's a question as to then how that might affect their ability to deal with cases involving violence or traumatized victims themselves. So I think that in Australia there is probably a need also for cultural competency training and accreditation for police, for practitioners, and for the judiciary, and also for corrections. So the question is how we deal with that, and whether it is something that is made mandatory at university law student level, or whether it's made a mandatory component of the of practitioners training, whether it is included as a part of the orientation for new judges, or as the ongoing training for new judges. Whether it's made mandatory at any level is a very difficult issue. But given the levels of over-incarceration, I think a very good case can be made for it to be mandatory, in that at least it will go some way to training or educating the profession and the judiciary and the other sectors of the justice sector as to what the history of this country is. And if it's not going to be taught in schools, at least the justice sector can be made to understand the real history as it occurred, and the trauma that has been visited upon our communities. Thank you.
Thanks very much, Tony. Thank you. Yeah, it's a tough problem, and not one that we're going to solve easily. But I think that those recommendations could go at least a small way towards addressing it. Dr. Tracey McIntosh, can I ask you to reflect a little bit further on the New Zealand experience, and in particular your extensive research and involvement in prison programs? What can Australia and New Zealand learn from each other?
Yeah, I mean, I think it's a really interesting thing about how we can learn, what are the elements. I mean, one of the things I just want to come back to is this issue around imagination. And, you know, I often draw on the work of those who look for a jailbreak of the imagination, recognizing that that's one of the biggest blocks that we have, that we think that the system we got is somehow a natural system. It's not a natural system, it's a socially constructed system. It works to privilege certain peoples within it, and the cumulative disadvantage is just so entrenched. So that imagination, I think, is a really important part of decarceration strategies and prison abolition more generally. And I think it's a really important element for us to think about what Indigenous imaginings are of a just society and of just conditions, and, you know, sort of see that very strongly within a transformative space. I think that there's one of the things that I feel really heartened for. I think there has been a change in the conversation in Aotearoa in New Zealand, that we have got a Minister of Justice who will say that the system, the criminal justice system, is a failure. The fact is, what we do also find that even when we acknowledge and recognise that failure, it remains a fully funded failure. And that's where the justice reinvestment that you're talking about, that's such a significant element. Because at the moment, the status quo is around the status quo being a fully funded failure. And so just sort of reflecting on what that means in terms of those changes in restorative spaces. I think, and some of this is a demographic element, some of it is because as Māori, we do have political power. Some of that's around numbers. There's others that talked about in terms of the importance of knowing your history, the importance of language, which I've seen has come up, and seen what the renaissance in terms of language. And of course we have some incredible, you know, very, very different schema in terms of that we might have different dialectal issues, but we have one language that we can understand in terms of te reo Māori right across the country, what that means. I think there's been significant investment around young people, but not enough. I mean, the benefits that we see within our youth system still have largely accrued to non-Māori. So there, you know, there's elements that we can do. I think there's been a recognition. We had a commissioner of police, our last commissioner of police, who talked about in the beginning around the unconscious bias within the police. Certainly near the end, he was just talking about the difficulties of shifting a culture in an institution, talking about the police that harbours bias. So I think there, you know, in terms of the conversation has become far more mature, far greater. We have this incredible, you know, group of young people, both Māori and non-Māori allies, students, activists and others really working very hard in this area. And I think it's one of the things, you know, to recognise, particularly in the decarceration and the prison abolitionist space, so with both Just Speak and with Papa. Now, these are two largely youth-led organisations, or young people, rangatahi, that are leading that sort of conversation. So we are seeing those sorts of shifts. So, you know, the need for the consciousness and the political will and real accountability. You know, coming back to Tony's point, I believe we have a right to know why we are where we are. That's a really fundamental right, to know our histories and to be able to share it and have that history acknowledged. When you ask someone why they're in prison, they'll often talk to you about the offending. If it was just around offending, we would expect to see a much more diverse prison population than we see. The fact that our prison populations are poor, that they're young, and within our countries are largely Indigenous, speaks to far more collective types of forms. And so this need to know why we are where we are at a national level, at a community and personal level, I think is really important around what those elements are. So I think, you know, we need to work more together as well, in recognising some really significant differences in our system, but also recognising the places that we can work together.
Yeah. Thanks, Tracey. Do you think, I mean, what's the priority in terms of, everyone's referring to justice reinvestment as being a real priority, and including you. The police have a really important role in the justice reinvestment model, so that there's a real dialogue between police and members of the community. Do you think that's a major priority for justice reinvestment? How do we shift from being crisis driven in the criminal justice sense to more preventative responses?
And I think we need real, I mean, in the transformative justice space, and I think in a more critical justice reinvestment, it's around alternative to policing. I just don't know if you can just use policing that becomes more culturally competent, that has greater levels of cultural proficiency, and think we'll get different outcomes. We need real alternatives to policing. And I think, again, with the decarceration strategies, that sort of sits within it. It is around empowering, truly empowering, resourcing, allowing those communities to make decisions around how they deal with harm within their communities. And it does mean high levels of community accountability. And if that's resourced at that place and that power is given. So my concern always is around that we just reproduce the one, or we think that cultural competency and cultural proficiency, while absolutely necessary, and I don't doubt that that's necessary within those institutions, that will create the conditions for change for our people. So it's really much more around alternative strategies of policing outside of the police. Just to think about mental health checks, for example. So when there's a mental health check, the fact that we send police for a mental health check speaks to the poverty of imagination within our communities. Why would we send police to do mental health checks? In many cases, these can be accelerated and amplified up where tragedy ensues. And so, we have to think about what do we need to do in terms of capability and capacity building within our communities, that there are alternatives to policing to create really greater levels of collective security, so that the best way to stop that pipeline into prison is creating the conditions for a just society.
Thanks very much, Tracey. Hannah, I might pass to you for a moment. There's a question came up from the audience. How do we achieve cultural change across the justice system, including with respect to policing? And how does that interact with justice reinvestment? And your response to what Tracey's just said about transformative justice, where you move right away from policing altogether?
Yes, well, certainly the establishment of the Aboriginal Justice Committees and that partnership commitment is absolutely integral. The policing and the problem that we're not really identifying as such about implicit bias or unconscious bias, or in policing is really having a heavy hand on Aboriginal people, and we can see from the report the discrimination that is occurring at every level of the justice system. You know, how do we deal with that when we don't actually want to acknowledge that there is a discrimination problem? And the current approach seems to be about teaching Aboriginal police cultural awareness, and it's certainly not working. And the mirror really has to be, you know, reversed back to non-Indigenous society to, you know, start actually examining this and being real about it. There's been some groundbreaking research from ANU researchers over 10 years showing implicit bias is very real towards Aboriginal people. And I think they found that possibly even 3 out of 4 people hold negative views about Aboriginal people. So it's not just the police, we're talking about society at large. And this reconciliation process that we went down has kind of deflected attention, I think, from this really shocking human rights situation that's happening. And when we have very clear evidence in the justice system, as we have had in WA in regards to police interaction, and the evidence was about traffic cameras and the differential results to actual when policing were involved, it was much, you know, more overt and discriminatory. And the response was simply a handballing situation in the state between the police commissioner and the Minister for Indigenous Affairs, you know. So there's this really running away from this core issue that's been ongoing for so long about discrimination and the way that it's taking place in Australia today. And yeah, we, you know, until we address that, and, you know, as the questioner from the audience talked about, some of the video footage now, we're in the world of mobile phones and cameras and recordings. And so the evidence is actually being, you know, very clear now. And the case of Miss Du, who died in the Port Hedland cell under the watch of so many police officers, with sympathy only from the youngest recruit, a female young recruit, and involvement of health professionals as well, doctors and nurses who also showed that racism conduct towards her. So we're talking about this really whole of society wide issue that really is driving what we're seeing here. And the leadership does need to come from some key, I think, key people and sectors in the justice, including, I would like to think, the judges of Australia, to know that, you know, they're involving in themselves in, you know, this sort of treatment of Aboriginal people. We had a shocking case last year of a grandmother with dementia who was actually sent to prison for a week over a neighbourhood dispute. And, you know, it just gets a bit of media attention, then nothing is done about it. You know, there's no acknowledgement. So yeah, it's time for these really honest conversations and dialogues about actually, you know, the racism and what's actually happening here.
Yeah, thanks, Hannah. How do you see that we can reassure the community that this implicit racism and their fears of Aboriginal youth, Aboriginal people are unfounded? How do we assure them that their safety is assured and that investment in community is the answer rather than sending people to jail?
I think that the longer we avoid that issue, there's safety risk to non-Aboriginal people. The violence isn't just inwards. This is obviously going outwards. This, you know, the violence against Aboriginal people obviously is playing out. It's extremely, you know, there's real long-term implications. I've been advocating recently for young Aboriginal men from the outer home system in prison who have been subjected to solitary confinement. For one prisoner I've heard today, 10 months, another young man, 7 months. Do you think you can treat people like this and you're going to live in a safe society? Certainly not. You're going to potentially experience harm as a result of, you know, the harm that society is allowing and participating in, clear violations of international human rights law. And yeah, that is something that we don't really talk about very much, how, you know, we as Aboriginal women and Aboriginal people are not just the only ones who experience the violence and harm as a result of this ongoing denial and abuse of Aboriginal people's human rights. This is having implications throughout. And we know as well, like the fiscal costs, we don't talk about that very much, but the Law Reform Commission certainly pointed out the billions of dollars that you're spending on your punitive, you know, harsh approaches. You know, we should look at countries like Norway and their prison that is based on rehabilitation, where prisoners' human rights and their freedoms and their therapeutic needs are really are pivotal. I know this doesn't happen in so many places in the world, but we have to, you know, look closely at this, because that is how we're going to have a more humane, safer society. We can't be trapped in the past, the colonial past of this convict settler society that's been so violent and brutal to Aboriginal people.
The Portugal model too is worth having a look at. Carly, what's your response to that? How do we address those questions that Hannah's referred to? How do we reassure the community that that spending money on community works to keep people safe?
Yeah, it's a good question. And I mean, if anything, what we're seeing at the moment is certainly the facts don't matter. So we do have to query what is going to help. But I would say, and, you know, I'm reflecting on, I've just come from seeing two incredible Aboriginal women, the sisters of Nathan Reynolds, who died from asthma attack in a prison a number of years ago. I've also, the ALS is acting in a matter in Lismore, which has seen an Aboriginal man shot fatally. And so I think what's worth pointing out is that, you know, these matters, and the 18-year-old Aboriginal boy who was assaulted by a police officer in Goulburn, we've just seen that Kumanjai Walker and his killer is actually going to stand trial for murder. You know, all of these things really stack up. And if we're going to talk about how is it that we assure the public essentially to be non-racist about Aboriginal people, I think we have to take a different lens on it and say, well, what is it that the public are going to do to stop the violence against Aboriginal people in this country? How are they going to make sure that Aboriginal people are safe in their own country? How is it that they're going to hold the politicians to account when, you know, they come out with scapegoating policies when they're down in the polls in the lead up to an election and think that having curfews introduced is the right policy response? People in this country are smarter than that. And I think people are really starting to realise what this kind of populist scaremongering, scapegoating tactics are that people are using, where, you know, and we see it in the lead up to elections all the time of, you know, is your neighbour trying to steal your job? Or, you know, we have to stop immigration or Aboriginal people. All of these things are designed to pit people against people, to make sure that the minorities are the focus of this deficit model. And so I think what we have to do as a society is just, you know, let those few politicians that are trying to turn us against each other to say, we're onto you. You know, we're not going to let you kind of keep doing this. And for me, we have to make sure that we have got really strong, accountable institutions, because at the moment, there are certainly some questions to be asked. You know, we still have police investigating police, for example. There are things that we can do to turn this around. And I think we have to be asking the right questions that actually focus on what is it that non-Aboriginal people can do to create safer places for Aboriginal people on their land, on sovereign land.
Thanks very much, Carly. Tony McAvoy, what are your reflections on that? And also turning our gaze inwards for a moment, what can we do as a legal profession here to address some of those issues and to overcome the overrepresentation of Indigenous peoples in the criminal justice system? Are we doing well in some respects or not? And how can we do it better? You there, Tony?
The forces are stacked against us. There's no doubt about that. But I'm given some hope in that a very divisive and negative campaign was run in the Victorian state election, which the Victorian voting public rejected. And that negative campaign was supported by the usual media outlets, mainstream media outlets. And normally when you get that sort of, in the past, when you get that sort of support from a media outlet, it pretty much assures victory. But the community seem to me to be, in certain places, prepared to disregard the mainstream media and apply their own thoughts and logic. And it seems that the very thing that Carly was talking about in Queensland is failing to work as well, notwithstanding the attempts in the media and by certain political parties to try and create division and fear and hate within the community. At a really meta level, I have this view that much of what continues to plague us all is a colonial fear and hatred. And I take what Tracey and Hannah have said about the role of the police, and we need to think outside the box in terms of the police. I just would make the comment at this point that it must be remembered that it was the police who were responsible, especially on the east coast of Australia, for the large majority of the genocidal practices. And those stories prevail within our communities and families. But how do we approach that fear and hatred that exists? My view is that the Uluru Statement from the Heart, when it spoke of a truth commission, hit on something that is very important for this country, so that we get to a point where we can say, we know your grandparents killed our grandparents, and speak to particular landholders and say, but we do not hold it against you, and we want to be able to live with you. And we want to be able to get on with our lives, because the failure of you to move on, and the silence that you've had to bear through hiding the secrets of your great-grandparents affects us as well. So I know that not everybody's comfortable with truth commissions, but I think that there is a great potential there for moving that, what in many places in Australia still remains a very antagonistic and hateful attitude towards First Nations people. In terms of the Just Reinvest program, Justice Reinvestment, we will know that the government is serious about justice reinvestment when we have legislation in place that makes the fiscal link between changes in the community and savings to the justice and the system and the related community areas, and that funding is being taken from the law enforcement and and correctional and courts budgets where the savings are being made. And when that legislation exists, we know that the government is serious. But until then, we are just seeing I'm always serious. Small amounts of money being drip fed to organisations for things that might appear to be like justice reinvestment. So what can the legal profession do? Well, I think that the legal profession could do a number of things. It could support the creation of truth commissions so that we get to the point of what's happened in the past and why we have this relationship. It could, the lawyers must continue to demand that the government, each of the state governments and the Commonwealth government raise the minimum age of criminal responsibility to 14, because that is one of the starting points and entry points into the criminal justice system. I think that lawyers are duty bound to understand what trauma-informed practice is and understand what to be culturally competent when dealing with Aboriginal communities. If we achieve those three things in the near future, that would be a great start.
Thanks very much, Tony. Now, I'll put this one firstly to Carly and then to Hannah, I think. Is there a major topic or priority that was not canvassed in the ALRC's Pathways to Justice report that you think is important to this conversation? And Tony, feel free to jump in as well.
Thanks, Pauline. I think Tony obviously mentioned one previously and just now as well. Raising the age was not something that the ALRC report canvassed and recommended on, and that is just something that could be done immediately. There are a number of alternatives that exist. The government could take the money that it puts into locking kind of 10-year-olds up in prisons, and we know that this happens through our ALS custody notification service. The 10-year-olds coming into contact, there's the risk obviously of them being taken to a barbed wire facility, strip searched on entry, placed into a cell no bigger than a car parking space. We know that this happens, and so I think that is one thing. And of course, I think, as I said before, I really think, and although there was a recommendation for an inquiry into the child protection system and removals, and that is something that I really think should have been explored and was missing in the ALRC report, because we know, and the evidence tells us, that children who are removed from their families, from community, from culture, are more likely to go into contact with the criminal justice system. There's a care criminalisation that exists, and it's, you know, you'd see it just from things like someone playing with a ball inside breaks a window in an institution. Parents might deal with that perhaps in a grumpy way and be upset about that, but they're certainly not going to call the police as a result of a ball going through the window. And so I think for me, those are the two things that I'll point out.
Thanks very much, Carly. I'm just mindful of the time. I was going to invite the others to pipe up there, but I think we're running out of a bit of time. Did any of you particularly want to comment on something quickly that was not canvassed that someone else hasn't already referred to?
If I could just briefly say, even though it was canvassed, that the Pathways to Justice report didn't cover bias, and that is a very topical subject, particularly on the back of the report by Siddharth Shirodkar identifying that 3 out of 4 Australians have an implicit inherent bias against Aboriginal and Torres Strait Islander peoples. And when you think about the way in which discretion is exercised in the justice system, it's obvious that that will play a big part in the way justice is dispensed. The other thing I wanted to say is that the sector, the legal sector, I think should look at ways in which it can jointly come together and match the justice targets under the Close the Gap process, so that it's not just government but the justice sector as well, perhaps forming its own targets or list of actions that it will do at the same time.
Thanks very much, Tony. Hannah, any closing comments?
Yes, thoroughly agree with those questions, and they were somewhat disappointing, the findings around the police to review their own process. So we know there's an inherent conflict of interest in police doing their own reviews, and the standard under international human rights law, particularly where there's a death in the administration of justice, is for independent processes. We've had a review of the CCC, which has oversight of police in West Australia, and found that actually they're really not doing their job, and the relationship with the Aboriginal legal service was shocking. They were being so unresponsive that people were not even turning to them anymore. So this is highly problematic. We certainly do need more of a culture for human rights and need more lawyers at the forefront of that.
Thanks very much. And Tracey, anything in closing?
I just really to thank, thank my colleagues that I've listened to today, and thank everyone else. One of the things that came out of one of the reports that we've had in the last year, which was out of the Maori Justice Hui, the Inaya Tonu Nei report, this means we lead, you follow. And given our expansive, comprehensive understanding of the systemic embedded harms that are done, and the way that Indigenous people also know and understand non-Indigenous people, I think that's a really strong point to follow on, that we do have, we are experts of our own condition, and particularly around issues around incarceration. Unfortunately, we have deep expertise in our communities, within our prisons, within our broader practitioners. So I think that that's a really good thing to think about what it means if we led and you followed. Kia ora tātou.
Thank you very much. Well, thank you all very much. It seems to me then that the main things that have come out of this have been that we absolutely need to have those challenging discussions, and we have to follow through, and we have to ensure that the government really does listen to this report. It's critical that the system understands the close connection to the history of colonisation and trauma, to know why we are where we are, and we can't remain trapped in the past. We need to understand that the reach of imprisonment is long. It goes far and deep into the communities from which people come, and there are solutions which are ready to implement right now, such as justice reinvestment, Aboriginal sentencing courts, Aboriginal justice advisory committees, bail accommodation, and we need to think about where we would have been if we'd implemented these when they were first recommended. We may have prevented worsening outcomes for whole generations, and we need to stop funding failure. In the long term, what's needed is deep systemic and transformative change, and this is not something that can be fixed with tweaking legislation here and there. It means a true partnership between Aboriginal people, their representatives and governments to achieve real justice, and our profession has to be part of that. And now is the time. We need to keep the momentum going, and we need an equal partnership going forward. So those are the key messages that I see coming out. I'm sorry to all of our people who are watching that we didn't get time to address many more of your questions, but we'll try to, in some way, respond to some of those good questions that have come through. But I'd like to thank very much our panel, Tracey McIntosh, Carly Warner, Tony McAvoy and Hannah McGlade for being here today. It's been an incredible discussion, and I think it's raised these significant matters that Australia must address if it's going to achieve justice for Indigenous people. So thank you so much. It's very much appreciated, and I thank the staff at the Law Council too for facilitating this this really informative discussion. I hope you've all enjoyed it. Thank you very much. Good night.